The 5 critical features of India at its platinum jubilee, before I come to similar feature of the Indian Supreme Court, which I've tried to isolate. One is, of course, what I've mentioned, institutionalizing democracy. That is clearly a critical achievement. One person, one woman, one man, one vote, the festival of democracy, which has, barring an occasional aberration, subsisted and thrived. We haven't yet had, I'm not saying about today, till recently we haven't had the phrase which in a so-called mature democracy like USA had become part of the folklore, stop the steal. Stop the steal is something you wouldn't think of being used in US till a few years ago. But you had a stop the steal campaign, you have a stop the steal movement, you have the stop the steal thought process. So democracy is very fragile, even in the places you think that it is very entrenched. Now, unfortunately, we are now having some of these doubts coming in this country, which is why it is important for that very important institutional pillar of Indian democracy, the Election Commission, to bend over backwards to practice transparency, to be utterly transparent and transparently independent. Because once you start doubting the process of institutionalizing democracy after every 5 years of elections, and in a mammoth country like India, the size is unbelievable, then you will slowly be deinstitutionalizing this great achievement of democracy. The second is that we've had constitutional democracy. It's not just democracy, not just elections. We have entrenched a whole set of constitutional values. I mean, every time I pick up the CAD, the Constituent Assembly debates, I always come back awed and amazed. Here were a group of people, now I would say in retrospect far wiser than us, who were surrounded by fundamental wrongs all around them. And as Granville Austin put it beautifully, from out of these carnage of fundamental wrongs around them, in 2.5 years, from 46 to 49, 3 years, they fashioned fundamental rights. They were very scared of fissiparous tendencies of the Indian Union, which is why they designed something more centric and unitary than federal. But they still spoke up for a liberal, human rights oriented, fundamental rights oriented system. It's easy to talk about it now, but if you sit in that assembly from 46 to 49 with 2 million people dying, trains coming with bodies, with complete distrust, with animosity, with communities, with fire, to design a constitution like this, to think like that, to not make India a theocratic state, to provide for such ringing declarations as you find from Article 14 or 13, right up to 30, 32, to even conceive of them is quite an achievement, is a remarkable achievement. And along with that, you designed not a constitutional democracy, but you also designed or attempted to design a social democracy, something which the Germans and the Europeans talk about, that we have a social democratic republic, etc. Here you went to the Irish constitution and picked up this remarkable concept of directive principles of state policy. You added to it later, of course, much later, duties. But this whole dialectics of accepting that fundamental rights do have primacy, they are enforceable and they are vital. Though it was easy for the majority to deny fundamental rights in those troubled times. And then to counterbalance them by saying that though fundamental rights will remain priority, they must be imbued by the interpretive approach which looks at social democracy and all the articles in our DPSPs, Directive Principles of State Policy. And that complex interplay. So this is something which was again quite a miracle, something which historically we take for granted but needs to be celebrated. The framing of the Indian Constitution was itself a democratic act. It was deliberative, it was inclusive, and it was visionary. Figures like Dr. Ambedkar, Rajendra Prasad, Nehru, and many more recognized that the Constitution must reflect both ancient India's pluralism and its modern aspirations. Again, please rewind yourself and put yourself in those seats. To think like that and to create like that in those times is not easy. It was a product not of conquest, but of consensus. At its heart, they strove to enshrine the four cardinal values of justice, liberty, equality, and fraternity, each a bulwark against authoritarianism and inequality. These values were not ornamental, they were designed to shape governance, society, and citizenship. Through the doctrine of transformative constitutionalism, of course, Indian courts have taken this story much further. They have recognized the Indian Constitution as a dynamic instrument meant to foster social change. It does not merely limit state power, it mandates social justice, inclusivity, and dignity. And the basic structure doctrine, evolving from Keshwananda, reflects India's unique constitutional creativity. It asserts that democracy, secularism, rule of law, federalism cannot be legislated away, even by a parliamentary supermajority. And that, of course, is a later invention, but clearly I would put it in the category of India's pride and the world's envy. Though, sadly, in the last few years, we've had people with either less idea about the Indian Constitution or its spirit, or sheer ignorance, or bravado arising from political majorities, decrying, attacking, and denigrating this great concept. Let us now turn to some features of the Supreme Court as a bastion of all this, as a central theme in this journey of 75 years plus. Obviously, the constitutional text, already very vibrant, the product of 3 years of very engaging debate. And if you read the debates, by the way, there are completely contradictory views on the same page, on the same section. So out of the dialectics of thesis, antithesis, they somehow get synthesis at the end. And that's again no mean achievement. So this constitutional text, already imbued with the reflections and deliberations of the Assembly, was exponentially enlarged with constitutional context by the Supreme Court in the last 75 plus years, by multiple and ever dynamic layers of jurisprudence. 3 features alone, for example, judicial review, I always say, would make Marbury and Madison blush. The judicial review which we have today, which you study in your universities, would make Dycean theorists cringe. This is some different creature, a different species. It's all a development of jurisprudence by the court. The basic structure, which I refer to as the pride of India and the envy of the world, what a remarkable concept in one sentence. Even a constitutional amendment can be unconstitutional. Again, a creation of dynamic constitutional Supreme Court jurisprudence. PIL, with a lot of problems, a very unruly horse requiring a dexterous rider, and frequently the judges who are supposed to be dexterous riders are becoming more and more scarce. But despite that, it's done a lot of good. It's reached and addressed nooks and crannies which were insulated from scrutiny. So this again is a very unique Indian invention. And also you must remember that this starts from the identity of the Indian Supreme Court as a dual court. Again, it's unique. Probably very few countries in the world with this volume and this creativity and these frontiers have a dual role as a nitty-gritty, bread-butter daily court and also as a constitutional court. There is no division in this. And therefore, and each is important. People now say that you should hive off, you should differentiate. I have generally opposed it because it will weaken the integrity of the Supreme Court. And the nitty-gritty daily bread and butter sometimes very puerile issues which it decides are still necessary because they reflect a remarkable vote of confidence by the ordinary person in the Supreme Court. He somehow doesn't feel as bad when he loses in the Supreme Court after having lost everywhere else. And to take away that access to make it an abstract constitutional court or to intermediate a court of appeal as the final court in between may be an issue requiring a far greater discussion. I've tried to identify in earlier lectures 4 or 5 or 6 phases of the Supreme Court in an evolutionary perspective as Glanville Austin would have looked at it historically, not as a court deciding X or Y. The first phase was clearly that of the Supreme Court as a consolidator. Call it the 50s and part of the 60s. It was consolidating its jurisprudence. It was heavily reliant on English and other foreign jurisdictions, but it came into its own. It started consolidating on debt in use, on the Gopalan line, but the feature of this first decade or 1.5 decades was a marked pro-individual rights and pro-liberty approach. The second was a bit of a pullback from the 60s to the 70s, late or mid 60s to the mid 70s, and that had partly to do with politics and Mrs. Indira Gandhi. The pullback happened because of a perceived insensitivity to social rights. So this great emphasis on individual rights led to some pullback. It reached its peak, of course, in the early 70s because individual rights prevailed. And then came the pushback from the executive government, and then came a change in the thinking of the Supreme Court. The third phase was, I call it the positivistic Supreme Court from the 70s to the 80s, an excessively deferential court to the executive. You had the ADM Jabalpurs, you had the Liversidge moment of India, and you had the Dred Scott moment of India, both from the UK and the US. And it was clearly a decade-odd period of excessive deference, partly arising from the emergency context, partly arising from the relative feeling of chaos and lawlessness. But be that as it may, clearly it's an identifiable phase of an excessively deferential positivistic court. Look at the text, look at the technicality and decide. Don't go into the larger picture. Fourth was what Upen Bakshi said, a post-emergency quest for legitimation. So you had to do that because you had the Nadirs, the depths of the ADM Jabalpurs. So you had this post-emergency quest for legitimation. And this is the late 80s and 90s in particular, where you have this PIL coming up. You have, of course, the progeny of Justice Bhagwati's initiatives in the 80s, and so on and so forth. So it became an assertive, a individual rights oriented, and a vocal court. Then the fifth phase was, I would say, a greater focus on issues of equality, transparency, social justice, and environment. This is the decade of the mid-90s onwards. Pro-civic amenities, anti-corruption crusades, pro-environment, and of course issues of equality and transparency. And finally, you have now coming up to speed the current Supreme Court through several changing Chief Justices. A more liberal institution, dynamic and forward-looking, looking at frontier issues like privacy, technology, gender issues, not always getting it right. I'm only commenting about the subject and the phase. I'm not saying you got it right. They got it wrong a lot of times. But those are the broad 6 phases of the Supreme Court. However, this is my oversimplified attempt to put it within the capsule. The inconsistencies within each phase are marked. They don't do any good to the Supreme Court. When we started practice, we used to joke that there are 4 or 5 Supreme Courts functioning in that building. Now we are worried that we are somewhere around 15 to 16 Supreme Courts functioning in that building. And that's not good. That's not good for the power, the strength, and the integrity of the institution.